Hello everyone, good afternoon. Welcome to the fourth webinar of UGoveRN's Law and Policy webinar series. My name is Gümeç Karamuk. I'm a postgraduate research student and also a member of UGoveRN. I'll be moderating today's session along with my colleagues Ebru Kurt Özman and Michiel Stappe, who are also part of the organizing team of this webinar series. This session is about law and policy issues in urban regeneration projects. Before I introduce our panelists, I'd like to briefly mention about our network, UGoveRN. The Urban Governance Research Network is an academic platform for researchers to share, co-produce, and co-create knowledge on the topic of urban governance. The platform was initiated by Professor Tuna Taşan-Kok, who is Professor of Urban Governance and Planning at the University of Amsterdam. She is also joining us today as our discussant. The main of UGoveRN is to connect academics, practitioners, and communities who work in the fields of urban governance to create an interactive platform to discuss and collaborate on research projects and initiatives. Besides law and policy, our network focuses on two other research teams, planning and property, and space and society. Today, as I mentioned before, we're going to talk about law and policy issues in urban regeneration projects. We're going to talk about what are the breaking points in a neoliberal ideology and how it affects urban regeneration projects. We will have three presentations, starting with Professor Şevkiye Şence Türk. Then we are going to move with Professor Roberto Rocco, and then we're going to move with Dr. Joanna Kusiak, and each presentation will be 12 minutes long, which will be followed by a discussion led by Professor Tuna Taşan-Kok. Let me briefly mention about some housekeeping rules. The session is recorded and we are asking the audience to remain muted, but please do not hesitate to submit any questions anytime in the chat box, addressing everyone and engage in the discussion via the Q&A. After each presentation, we will check whether there are any questions. In case there isn't any, we're going to move to the next presentation. So for now, I would like to give the floor to Professor Şence Türk.
Thank you. Okay. Can you see my presentation? Thank you. Thank you for nice invitation. My title of presentation, Law and Abuse Flexibility within the Urban Renewal Process. I give from perspective. I give perspective from Istanbul. You see my presentation context. As you know, legal norms include a certain amount of legal certainty. Urban renewal law is expected to provide legal certainty. In the urban renewal, law includes should be include between certainty and a balance between certainty and flexibility. The disruption of the balance in direction of flexibility means abuse of flexibility. In the literature, especially Western literature, there is a positive perception related to flexibility, but when we look at the abuse flexibility, we cannot say anything positive flexibility. We can see negative flexibility. the aim of the study, I examine abuse of flexibility within urban renewal process and the effect of law on this. I examine two stages. At the first stage, I look at the renewal policy and laws at the macro level in Istanbul. And second stage, I examine urban renewal case. I choose Fikirtepe urban renewal case. In this study, the degree flexibility is closely related to three issues depending on certainty, discretion, accountability. First of all, I would like to begin a shift in Turkey urban renewal policy and laws. I divide two sections, trajectories. First period between 2004 and 2011. The second term is 2012 and until now. In Turkey, in 2002, general election was made. After general election, ruling party published the emergency action plan in 2002. This plan is quite important. Why? Because this plan focuses on housing policy and policy change is important. The approach is construction-based boom, construction-based growth, but housing construction. Under this approach, illegal settlements quite important. Why? Because their location is quite important. Clearing illegal settlements to make way for fruitful investment. And in that term, the state-led urban renewal use and large-scale housing projects were used in that term. Also, revenue sharing model important in that term. This model type of public-private partnership. And in that term, there is a different fragment laws. This fragment laws has some common nature. One of them is procedure, for example, easiness in land assembly, private laws implementation law tools. These laws include some private law tools. Urgent expropriation quite important. And the other important thing, these laws are used by passing existing laws. The main actor in that term, mass housing authority, centralized public institution, that the administrative and finance power to rapid and abundant housing projects. And the other actor, municipalities, metropolitan municipalities, private sector. In that term, private sector, large developers. These terms has some failures. For example, failure to complete large-scale project. In this term, large-scale project has started, but these projects have not concluded in time. Legal certainty is important. Also, there were problems in project management and organization, incompatibility to urban law and planning system, lack of public participation mechanism is quite important in that term. In the second term, crisis in 2010 is quite important. After crisis, the ruling party changed its policy. Why? Because the desire to keep economy alive after crisis, and this term has some feature. One feature is centralizing decision making. Or ministry has been strike and the change. The other important feature is the change in the size project. Piecemeal projects have been encouraged in that term. Why? The aim is to reap benefits of quick return from development. In that term, renewal at single building and plots is important. Urban renewal based on agreement between property owners and developer constructor, but developer here, small size and middle size developer and constructor. In that term, there is a one urban law important, and in this law includes easiness in intervention into ownership. Within this renewal law includes private law implementation tools much more than public implementation tools. And there are some incentives. The main actor here, Ministry of Urban Environment and Climate Change, property owners, developer, and constructor. Some failures, for example, over supply housing were realized in that term. Fragmented implementation is quite important. The renewal project were realized in certain high-rent regenerating part of cities. Infrastructural problems quite important. Lack of participation mechanism and lack of social sustainability quite important for that term. And I'm sorry. Look at Fikirtepe urban renewal. Fikirtepe is an illegal settlement. This settlement was established in 1950s. Now urban renewal project, the Fikirtepe urban renewal project started in 2005. Some part of the urban renewal project has been finished, some part of it has not concluded. When we look at before and after urban renewal related to Fikirtepe area, we can see increasing population, changing in population, increasing construction, increasing density, increasing density, decreased amount of social and technical infrastructure, changing social and spatial and social structure. This urban renewal project includes 8 stages. In this examination, I made interviews on the area, 25 interviews. In the analyze, I examine flexibility in the process according to each stage, and I examine also the effect of law. I cannot give all of them, but I give some summarized thing. In this summary, we can say the flexibility in the process in each stage. This quite important, and the flexible use means this uses and effect of law, direct effect, majority direct effect of law on this flexibility. Conclusion, considering the example of Turkey, direct effect of the neoliberal ideology can be seen on trajectories in the urban renewal. In particular, the behavior of market against these economic crises directly affect these trajectories. According to findings, the transforming law and policies have direct effect on those trajectories. In the first period, while large projects under state-led urban renewal is dominant. In the second period, the risk-reducing piecemeal renewal is seen. Therefore, their outcomes are different. However, both periods are far from solving the urban renewal problems in Turkey. What could be made to law to create more just society? I can give some suggestion. In urban renewal, according to findings, abuses of flexibility is dominant. There are important uncertainties in every stage, discretion and accountability problems. In renewal law, these problems should be removed. The roles of local governments on the process quite important, but the roles of local government on process should be increased. Nowadays, the role of the central governments quite important, but local governments' role should be increased, especially in the risky areas for renewal in cities should be identified by local governments, for example, for Istanbul. Also, relationship between planning and urban renewal should be established in urban renewal law. Nowadays, the link should be established. Problematic issue relationship between urban renewal and planning. Outside of agreement between property owners and developers, the cooperatives, Turkey has a lot of experience cooperatives in the past. The cooperatives should be encouraged within the law, in my opinion. Thank you very much. My references.
Thank you very much, Professor Şevkiye Şence Türk. She's Professor of Urban Law and Management from Istanbul Technical University, for those who recently joined us. And we're gonna move to our next presenter, Roberto Rocco, who is Associate Professor of Special Planning and Strategy at Boekunde, if I'm pronouncing it okay, at Delft University of Technology. And just so you can share any PowerPoint slides, I'm gonna make you a co-host. The floor is yours. Thank you.
Thank you so much. Thanks for the invitation. It's really a super honor to be here and a pleasure, because I'm a great admirer of your group, and of course of Tuna, whom I've known for many years. But yeah, without further ado, I think you can see my slides, right? Okay, I am going to talk about a few frameworks that I use in my teaching and my writing and my thinking about urban regeneration, and I'm going to deviate a little bit from the question that was posed to me. But yeah, the title of my presentation is How Rational is Rational Choice Theory, and I'm going to talk about something called the global commons. And I think it's important to tell you that as a Brazilian myself, I have witnessed the gifts that that democracy and redemocratization have given my country since 1986, when the military regime fell, and then a progressive politicization and a progressive growth of the far right in my country. So for many years, we made great progress in preserving the Amazon forest. It seemed like we were going in the right direction. And suddenly, with the inauguration of a new president, which is a far-right president, things really go down the drain very much. And that gave me space, or it made me think about a few things. First of all, that indeed globalization has, sustainability has three main dimensions, right? Economic, environmental, and the social aspect of sustainability. And I am really, really interested in understanding what is social sustainability and what are the conditions for social sustainability. Why is that? Without a functioning, accountable, democratic government, you don't have sustainability at all. You don't have environmental sustainability, and you don't have economic sustainability, as the demise of the Amazon forest clearly illustrates. I also think, and based on my research, that justice underscores social sustainability. So without spatial social justice, it's very difficult to attain social sustainability, and therefore very difficult to attain overall sustainability. And finally, I have to confess that I'm an institutionalist. I believe in institutions. And I say that because a lot of my students, for example, are clearly defiant and very wary of institutions. They don't like institutions. And they think, yeah, everything needs to be bottom up. I try to understand institutions from the point of view of formal institutions and informal institutions that exist, because I think to face the challenges that we have ahead of us, we need coordination, and we need strong governance, and we need meta-governance. If I have a chance, I will explain what that is. So the question I was asked to address was how to interpret the role of neoliberal ideology on emerging trajectories or breaking points of urban regeneration. And I wanted to twist it a little bit to talk about planetary regeneration, which I think includes urban regeneration. And I hope I will be able to explain what I mean by that. So paraphrasing Ostrom, who in 1998 made a speech in one of the many prizes that she won, she said, "You would not be watching this lecture if it were not for some of our ancestors learning how to undertake collective action to solve social dilemmas." And I think it's very important that we understand that we live by what Yuval Noah Harari, and I'm really sorry I'm citing a popular writer here, but I think this idea really explains what I mean, that we live by imagined orders, which enable humans to trust each other, because by following these imagined orders, we believe in the same stories and follow the same rules. And this enables us to cooperate with each other and to live together. For example, the state is an example of that. It's a completely imagined order. It doesn't exist in nature. Money, religion, institutions themselves, capitalism, and also justice. Justice doesn't exist in nature. If the sun explodes tomorrow, it's not unjust or unfair. It's just how the universe works. But I want to go a little bit further to explore the ideas of a Brazilian philosopher called Marilena Chauí, who, based on Marx and Engels, defines ideology. So ideology would be a kind of invented order, but ideology is very special, it's very specific. It's a narrative produced by the dominant classes that explains the world and legitimizes relationships of exploitation and oppression making them appear natural and universal. So ideology is a kind of narrative, really, but a narrative that has many holes. And if we reveal or if we fill those holes, the narrative will crumble, right? And the main narrative that I want to explore today is rational choice theory. I'm sure you know what it is, but I will just super quickly just remind everyone that we are talking about Adam Smith's invisible hand. And for Adam Smith, this invisible hand are the unseen forces that move the free market economy, that is through rational individual self-interest, the best interest of society as a whole is fulfilled. The exact words in the many writings that Adam Smith, I think he mentions the invisible hand four or five times in his writings, and one of them is this one. He intends only his own gains, and he, in this, as in many other cases, led by an invisible hand to promote an end which was not part of his intention. By pursuing his own interests, he frequently promotes that of the society more effectually than when he really intends to promote it. This means that if I put my interests first, if I put my own greed first, I'm actually promoting the well-being of the whole society because I'm promoting prosperity, I'm creating jobs, and so on, right? So this is really the narrative that underscores neoclassic economics, especially with Milton Friedman and the Chicago School. So what really underscores neoliberalism is this idea. So this free market fundamentalism has really pervaded every sphere of life and every sphere almost of policy making, right? I had a little clip, but I see that I don't have a lot of time, so I will skip my clip. What if economists ran the world? If we have time, we can go back to that. So rational choice theory asserts that political and economic behavior are best explained through the application of a supposedly value neutral assumption that, I'm always, rational choice theories that means that I'm always choosing for my own benefit first, which posits man as a self-interested, purposeful, and maximizing being. So I'm always trying to maximize my my well-being, my positive utility. Rational choice theory supports and perpetuates a political life, according to Richard Petrarca, an author who really criticizes rational choice theory and says that it's antithetical to tenets of normative democratic theory. So what Petrarca is saying is that the very idea of rational choice theory that underscores neoliberalism is antithetical to democracy. And I think we can see that how market fundamentalism has undermined social relationships in the United States, for example, where people just don't believe in collective life anymore, in collective endeavors and collective action. So rational choice theory offers, according to Petrarca, an incoherent account of democratic citizenship and produces a political system which shows a constant bias against political change and the pursuit of public interest. So it means that rational choice theory and neoliberalism imply the renunciation of public reasoning, public justification, and the erosion of the public sphere. And I think the best example we can think in urban development is how in countries like Brazil and Argentina and Egypt, for example, these private developments, how do you call them? Private private developments are popping up in which people renounce the city and renounce public services, renounce being part of a bigger collective to be in gated communities, that's the word that I was trying to find, in which they provide for their own services and they provide for their own, even sometimes their own energy and so on, and kind of renounce the space of the city, which is this space where we must live together and we need to decide how we are going to live together, right? I think this is super well illustrated by Margaret Thatcher in the 80s, coming up and saying, well, you know, there's no such thing as society. There are individual men and women, and there are families, and no government can do anything except through people. I think she was not as fundamentalist as some of the people we see today, because she does recognize we have to look after our neighbors. But I don't have to tell you that this kind of thinking, that the social unit that matters is your family, and the rest we have to each one fight for our own well-being. And this has profound implications for how we see sustainability. And here I have to really apologize, because if you have seen my lectures, you have seen me give examples about the commons and explaining the commons using the example that Harding uses in his famous article that is 60 years old, I think. So, you know, many people will think, oh my God, there comes Roberto again with his cows. But I will explain the commons just very quickly so that we are all on the same page, and then we go forward. So to understand sustainability, I need to understand what do we need to sustain and what is it that we want to keep. And I think the commons are very good examples of that. Let me see how I'm doing in terms of time. I think, so this is the example. We have four people and they own a field. And each of these people, they put a little cow in the field. So each of them earns the positive utility of the field of +1. So we have 4. But one of the people involved, he has a heritage. He got money from his grandfather, and he puts 4 cows in the field. So here you have, he earns 4, the field loses the positive utility of -7, which means that each person lost 1.75 of the positive utility of the field. So what does that mean? It's a little bit complicated, but it means that there is a big incentive to put more cows in the field to graze, because it maximizes individual profit. And there is a little incentive for them to control the number of cows, because of the negative utility and negative externalities are shared. If we follow a neoliberal thinking and a neoliberal way of understanding things and rational choice theory, this means that in the end, the commons will collapse, because everybody wants to put as many cows as they can. This is known in some places, is justified by this idea of the lifeboat hypothesis, which is the idea that we are in a lifeboat with 100 people around us drowning, and they are going to get our resource. And if we don't control our resources and don't keep others from exploiting other resources, they will get them all the resources, and we are all going to die. This is a profoundly misguided, misleading metaphor, because it implies that people are not able to cooperate, that they are so desperate that they will kill for the resources, and that there is no possibility of agreements here. And of course, in this case, there are no possibilities of agreements. So it's incompatible with the creation of public goods and the public sphere. Incompatible also with the preservation of life on this planet. So there are many people challenging this idea and thinking, well, imagine what economic theory would look like if the basic unit of behavioral modeling wasn't an abstract bourgeois male individual, but a mother. What he's trying to say here is that there are alternative rationalities in the world, and that we can obviously understand how we share our resources in very different ways, and that maybe rational choice theory is a very European way of looking at the world, and that other societies have seen this in a different way, like Ostrom and others have demonstrated. And ideas about this have penetrated communicative planning and public rationality. Not only the needs, and here I want to highlight the fact that Amartya Sen, for example, he says, well, we don't only have self-interest, we also have values, conscience, freedom, ethics, moral feelings, and codes which determine how we organize our societies and how we decide to live together. So he says, well, you know, we are not in a lifeboat surrounded by 100 people drowning. We are actually in a big boat all together. And because we are in this big boat all together, there is nobody out there. We need to decide how are we going to share our resources. And he says, well, there is a special case to be made for the preservation of the environment beyond the satisfaction of our needs and the preservation of our living standards. He calls this the duty of care that we have towards the planet. And he says that this means that our freedoms, so let me just go back a little bit. Humankind as a powerful presence on planet Earth has a duty of care towards the planet and its biological systems. And by doing so, by extending the rights to nature, we are in fact extending our own freedoms, including the freedom to meet our own needs, which he calls sustainable freedom. And here I finish my talk by looking at our big commons over which we need to make decisions all together. Thank you for listening to me, and sorry, I really went a little bit overboard with the time.
That's totally fine. Thank you so much, Professor Roberto Rocco. And I'm just checking if we have any questions. Just want to remind the audience that if you have any questions, please put them in the chat box so we can direct to our speakers. And for now, we are going to move to our last presentation to Dr. Joanna Kusiak. She's a Junior Research Fellow in Urban Studies at King's College at the University of Cambridge. And the floor is yours, Joanna.
Hello, I just, let me just share the screen and see if it works. Oh, sorry, I just see that the screen sharing doesn't work. They tell me I need to enable something.
Let me see if I can help you with that. I can perhaps make you host in that case.
I think I am host already.
You're a co-host. Yeah. Below the screen, do you see a share screen?
I think, wait a second, I think I need to, because I had my, very sorry for that, but I had my computer reconfigured recently, and I think I need to press this one box in system preferences to make sure I'm allowing it. I think that should fix
That's
this.
totally fine. Meanwhile, perhaps I can just make a short summary of what I have thought about the first and the second presentation.
Zoom tells me I need to leave and rejoin. So you do the summary and I rejoin with the screen sharing option.
Yeah, I think it's about system preferences, and that happens unfortunately. Hopefully we will soon have Joanna. Meanwhile, I would like to thank again to our two presenters, Professor Şevkiye Şence Türk and Roberto Rocco. For those who don't know about Law and Policy webinar series, we had our first first episode back in January. It was Law and Policy webinar series introductory session with Professor Ben Davies, Professor Rahel Alterman, and Professor Francesco Cildini. And yes, welcome back. Okay, I guess this should be working now. Thank you so much for joining us again. Yeah, I was just saying that this we will soon be able to upload the first session of our webinar series on YouTube. So there are lots of points that are tied back to that session as well. So I definitely recommend the attendees to check that and watch the space for UGoveRN's YouTube page. And we can now start with Joanna's presentation. Thank you so much. Joanna, sorry, you're unmuted. If you can mute yourself.
Hello? Now? Okay, but now I don't hear you now. That's
I'm here just in case.
Oh yeah, now I hear you. Fantastic. Sorry, one would think that after 2 years of pandemic, Zoom is not going to surprise us anymore, right? But it turns out I had the whole system reconfigured, and then all these things, all these problems emerged.
No worries.
Well, thank you so much for the invitation. I mean, thank you, Hubert, for the direct invitation. Thank you, Tuna, for creating this very interesting network and the opportunity for exchange. And already from listening to these two presentations, I got a sense that the strength of this network is diversity and bringing different scales, different perspectives, the micro, the macro, the material, the ideological. And I think I'll fit into this in a way. I'm not a planner, I'm a sociologist, and I am interested not just in law and policy, as the title of the series suggests, but also in this nexus of law, policy, and politics. And all that also at 3 different scales, the local municipal one, the national one, and the global one, and how all those 3 scales intermingle to produce certain urban results that again are then material, the cities that we live in, the certain shape of those cities that we live. And the particular case that I will discuss now, and that's a case from my book that has been already published in Polish and it's upcoming in English, which deals with a very certain type of, you could say, urban regeneration, which is also the systemic transformation. I'm speaking about Warsaw and the material, legal, and systemic changes that the city underwent between 1990, so the moment of shock therapy, so radical transition from the state socialism to very neoliberal. I mean, again, thinking of the last lecture, full-on neoliberal ideology that was incoherent on different scales, as I will show, and that was being translated into law and policy, and that was being handled by politics in terms of concrete people managing decisions, thinking they're rational often, and in some sense not always was the case. I'm starting with this clock that you see, which became maybe a central metaphor for the transformation to capitalism in Poland, and this metaphor I think is richer than originally planned. This is a clock that was put on the Palace of Culture. Palace of Culture is the Warsaw icon. For years this was the highest building. It was also technically the gift of Stalin to Poland, so symbolically also very powerful axis of the city. And of course, the building that evokes a lot of emotions like love and hate. And one of the ideological moves of the transformation was turning it into a big clock tower, which was officially called Big Benization, and was yet another way of proving that it is the ideological switch from looking at the east to looking at the west, now London and not Moscow. And the mayor, the back then mayor of Warsaw, when opening this clock, he said this is symbolized the new time, the time of capitalism, the new reality and the radical break with the former ideology. Now, what is interesting from the perspective of space and policy, that as much as putting this clock tower is still considered as the most successful intervention of the regeneration of the city into new capitalist system, the Palace of Culture stands on a huge empty square. And throughout the whole transition, from 1990 till now, all the governments, all the municipalities were struggling with the square around it. So, no, I'm not sure. Oh, yeah, that's how I put the next slide. So this is this collection of booths is actually the immediate square around this Palace of Culture in the 1990, in this short moment where from this ideological empty parade square, as it was called, it turned into the biggest bazaar of this kind of spontaneous grassroots capitalism, where you could sell and buy illegal guns there, fake, counterfeit clothing, all kinds of weird and not weird objects. And the square, and then it changed. Each municipality grappled with how to deal with this big empty square, and there were phases. So there were these booth bazaars that they were removed at some point. Huge car park, a fun fair. That there's been a plethora of temporary structures coming and going, and the plans to build certain. But in fact, till now, it's a mixture. They're building a new museum now, but the big chunks are still a car park. And this square has always been the symbol of what in Warsaw is called spatial chaos. This is one of the headlines, from many headlines, the news I collected during my research. They say the spatial planning in Poland is ruled by chaos. And this word chaos became an ideological word that, as I have been showing in my research, also fulfills this ideological function of concealing the actual legal and political orders that are operating behind it, and they are producing these types of spaces that are perceived by urban citizens as alienating, unfriendly, unhomely, or just plain ugly, and that's this chaos. In fact, is a complex collection of orders that in my work I was trying to disentangle, and I will give you a glimpse of this disentanglement in this presentation. I also think that this metaphor of a clock that is put in front of an incredibly messy, alienating space, it's an excellent metaphor for the whole transformation in terms of law and policy and space and time. If you look at the narrative about transformation on the national level and on the international level of institutions like the World Bank, the International Monetary Fund, all these global capitalist institutions that were pushing Poland towards a certain direction during the transition, they all produced this narrative of catching up that I'm sure many of you know, that in some sense they despatialize the narrative about the city, claiming that it's not the difference between capitalism and socialism. It's not the difference of spaces, it's a difference of time. We're just backwards. We just need to push ahead, push the policies, and the spaces will automatically become just like they are in the West. And from this ideology and from this push, I have documented how a lot of policies implemented on the national level are in denial of space. They're really implementing this abstract temporal ideologies and completely deny space. And I think there's no time to discuss all the examples. I just named two things. I mean, one, that I analyzed all the documents related to transition, and the word space, or even the word city, barely appears there. It's very interesting, as if it's not a relevant category. But also in 1994, as a result of one of the most important was poignant reform of the spatial planning, including the abolishment of all existing spatial planning. So turning Poland into the tabula rasa in terms of planning, where, I mean, there was a delay date because they realized that just lifting all the planning all at once would produce even more chaos. But the idea was that there's like 5 years of slow disappearing, but any planning document that was prepared before 1994 basically lost its validity, leaving the country completely without this planning structures. At the same time, and this is what I call a certain mismatch between the logics of globalization and the ideological logic of transformation, is that from the literature of globalization, we know that these are precisely the cities that are in the core of globalization, and there's extreme capital pressure specifically on cities. Of course, cities are parts of the state, but we know that the process of globalization means weakening the structural importance of power of the city, relatively weakening. Of course, it didn't disappear, and making cities as a sort of nodes of capital more important and more central. And on the one end, of course, we have cities like London and, well, London after Brexit it changed, but let's say like London and New York, which have separate power from US and UK. They are their own powerful nodes in this own terms. But at the same time, then we have other cities like Warsaw in the 1990s that do not have these powers, but they're really exposed to the pressures of capital, because there's this overflow of capital that seeks what David Harvey calls a spatial fix. So a way of, it's like flowing over of the capital to change the cities. And having these two logics, having this flowing capital at the same time where the national government, as part of ideology of transition, abolishes all spatial planning in the country, of course, created a situation where this logic of capital got enormous leverage in terms of what was happening in the city. And this is one layer of how Warsaw looks like, that you can mostly recognize by the dominance of big shopping malls, that there was almost unprecedented number per citizen and per square meters in Warsaw in the 90s. And it almost looked what we in Polish we call parachute architecture, so something that seems like it's just dropping to the city. It's disregarding the existing spatial order afterwards. And this kind of logic, of course, is not specific to Warsaw. In a sense, we all know this flows of capital that materialize as a form of certain type of architecture and certain type of urban space. But then there are also other types of logic that are a little bit more idiosyncratic, but they have at this core also this strong protection of property as a legal form that assures the form of turning land into capital or squeezing capital out of the land. And therefore, as we observe in the Polish planning, all sorts of legal regulation become subordinated to the concept of private property, either directly through certain forms of policy or indirectly through the types of implementation. Because looking at the different scales, I also, like as a sociologist, I like to look at the law on the three levels. I mean, there's a policy or sorts of legislation, there is implementation, and then there's implementation of the law. So how this flexibility also that we heard about in the first lecture, how it is exploited by the local actors and pushed in many different directions, which is what I claim the very moment in which politics happen within the sphere of law. And in my opinion, we should not deny it, but rather learn to manage and to acknowledge that within the flexibility which is characteristic to law and unremovable for law, and for good reasons, because it gives law this flexibility, there is a space for politics. And I think this politics of law can only be democratic if we are open about this flexibility, and if we're open about the fact that law is not a separate, neutral, technical sphere, but it belongs to the domain of politics, and it is being shaped also by certain political reasons. So I would like to show you two interesting forms, spatial forms maybe, that came out from more local idiosyncratic politics-related logic of transformation in Warsaw. And I chose these two examples because I also want to show that law operates both through implementation and through the neglect of legislations or even implementation. So one very small-scale idiosyncratic example that is very prevalent in Warsaw is what we call farm strip urbanization. So it is what you see on the left-hand side is a classical Polish farm strip that comes still that has to do, I mean, this form that people have farmed on these long strips that comes, the shape of the landlots attached to it comes from basically two historical reasons. One is technical. I mean, it is easier for the horse to turn, not that many times. So it goes just all the way and then all the way back. And therefore that makes it more practical in terms of farming. And the second is heritage. So usually a peasant who owns, I mean, in Poland, you didn't have the tradition of a huge agrarian feudal empires. They existed in a very, there's only few of them that belong to the gentry, but most of the peasants, they really had this relatively small strip of land. And then if they had two sons, for example, through the inheritance, the strips became thinner and thinner because, again, of this logic, you would just make them as thin as possible. Now, as part of the capital pressures on Warsaw, especially on Warsaw periphery, the Polish farmers discovered from the parts of Warsaw that were protected by the planning law before as green airing stripes that allow for air circulation and that are also left there for the food provision, that where you classically found tomatoes and cucumbers mostly. Through this sudden abolition of planning and also a couple of administrative reforms on the municipality level that we don't have time to really dig into, they became free for squeezing the capital. And also those farmers in the 1990s, because shock therapy was also connected to complete deregulation of farming, all of a sudden those farmers discovered that instead of farming tomatoes, they should farm houses. Basically, it's much better. It's not just much better business where you can make more money. It's also they structurally didn't have a choice. It was a mixture of, well, this self-sustaining policy where you see that you couldn't do by farming, and also a local initiative of local politicians who at some point really discovered that developing houses is a more profitable business. However, one way of dealing with it, which is typical for many Western cities, would be to issue a new redevelopment where you just connect all this stripe, redivide them into urban-looking landlots, and then divide them into little squares to build houses. Now, the ideology of private property has been and remains so strong in Warsaw that in all my interviews, it was clear that almost non-politician would dare to touch upon this property order, no matter if it makes sense for spatial planning. And so from there, the new type of urban development emerged in Warsaw, which is, you know, multi apartment condominiums that exist on this very narrow strip of farming land. Here you see one of the very extreme examples in the city of Białowieża. And I show you two pictures because this picture looks shocking, but it doesn't show the whole building, which if you look from the top, it looks like that. So it has a very narrow front, but it's actually a huge building that at the end also you see the parking lot. It means that, you know, the access to the building is not optimal, but at the same time, it's as many apartments as you can squeeze onto a landlord that is basically its form was prepared for like low technology horse farming of the land. I mean, so that's the genesis of this type of development. So this is one spatial form that comes more from the neglect, and the second one that goes maybe now deeper into the sphere of law enforcement and of solving historical political issues through the law is the question of property restitution. And again, I published a lot about it. I just give you a glimpse because we don't have time, but let me show you this building and I explain to you briefly. So Warsaw has been completely bombed during the Second World War. Almost nothing left. I mean, 70% of buildings were razed to the ground. And then it's been rebuilt as a modernist city, which means different in terms of grid. I mean, the buildings do not look the same. You can have hospital where you had previous apartment buildings and so on and so on. Because of this mismatch between, you know, the city, how it looked before the war, and the city, how it looked after. Because of the fact that Warsaw was completely destroyed and then rebuilt with public money after the war, the property restitution, unlike maybe another post-socialist country, it was really highly controversial political issue because it was clear that it's not a matter of the same building that was taken away and we return it to the owner in the same form. I mean, it's clear the building disappeared in the meantime. There's a hospital there instead of the building, and this hospital was built with public money. So it's not intuitive that it would be an instance of historical justice to just return it to someone. So for this political controversy reasons, till now, even like 30 years after the transformation, Poland never legislated any property restitution law. There were 25 projects of such law, and all of them were met with such political resistance on different levels that none of them was ever implemented, which basically means politically this is an unsolved problem and the restitution should not proceed. At the same time, at the time where I started my research in Warsaw, you could see that there's a specialized group of businessmen who are buying up property claim from historical heirs who are not sure if they will ever get anything from this claim and who are often very old, about to die, and so on. So there were this group of political businessmen buying up this claim and cooperating with also a relatively small group of high-end lawyers to create a legal patchwork. What they did is basically they combined laws from three legal systems, pre-socialist, socialist, and democratic, to create a legal assemblage using the flexibility of law to take over the buildings or to take over the most expensive landlots in the center of Warsaw, which is also the most expensive land in the whole Poland. And that resulted in a lot of human misery, of course, I mean, evicted tenants and so on. But the question of my research was also, how is it even legally possible? And when I dived into it, and I described it more in my article in IJUR, International Journal of Urban and Regional Research, is entirely through legal fiction. And I'm showing this building because this building was defined by the law as the single family house through a sort of legal loophole where you see the building and, you know, it doesn't look to me at least as a single family house. But because there was no legal definition of a single family house, the lawyers decided that any house that meets the housing needs of one family is a single family house. And if there's a family that has big housing needs, I mean, perceived by them, then we can define it in this way. So I speak in this context of judges stealing the political conflict from the public sphere, and therefore also I call it dispossession by restitution, playing with Harvey's notion of accumulation by dispossession, because you show how this, I show how this flexibility of law is secretly harnessed, because this was at the beginning stages completely like beyond public control, because unlike politics, law doesn't have this public transparency, I mean, not in terms of what's going on in the courts, in order to take over this most important, most precious land in the city. Now, there's a long after history of it that we don't have time, because I believe my time is over by now, surely. But I just want to end with this reinforcement or a thesis, you know, that if we really want to understand the role of law in urban planning, or in not just in urban planning, but in urban reality, in the things that come out after the phase of planning, we have to be attentive, on the one hand, on this deep legal technicalities that do not often occur in the public discourse. But we have to be very clear that legal flexibility is a political matter, and the terms of flexibility should be publicly negotiated as any other political issue. Thank you very much.
Thank you so much, Joanna. It was a very interesting presentation, and Warsaw, I mean, to my knowledge, is not a quite shared city, I guess, in urban studies. So it was quite interesting. We have a question, but I propose we move on with our discussion at Professor Tuna Taşan-Kok. And she is a professor of urban governance and planning at the University of Amsterdam, Faculty of Social and Behavioral Sciences. And Professor Tuna is going to interweave the three presentations we just heard. And the floor is yours. Thank you.
Thank you very much. Thank you all for being here, and all these very interesting discussions, bringing us from Istanbul to Brazil to Warsaw, all very interesting countries and contexts. I think flexibility of law, or legal flexibility, seems to be the common theme of these presentations. And in the background, I kept thinking how context of urban governance is increasingly changing and taking a form of a complex collection of diverse instruments, institutions, and laws that, on the one hand, try to create a regulatory environment to keep a very fragmented legal basis or regulatory environment in one place to control it. On the other hand, give freedom to individuals in the society and bottom-up initiatives to keep democratic rights in place. So this form of regulation, in my view, contains complex regimes of accountability. And Şence talked about accountability in the case of Turkey's legislative transformation, which actually followed the neoliberal political economic ideology to begin with. But then, listening Şence, I thought one more time that how true it is that neoliberalism is not only an economic project, but it's also a political project. Because in the case of Turkey, I think we see that there is a rather authoritarian transformation, a very centralized transformation of regulation, adapting the neoliberal political economic ideology, that how in this transition, how local democracy gets a little lost through the legislative transformation of the urban renewal law. Using the law and many fragmented pieces of regulation, the state actually creates comforting, flexible legislative conditions to justify its infiltration of capital through state apparatus into cities. Perhaps I should ask here, Şence, whether law maybe becomes a tool for depoliticization of local governments in the meantime. Meantime, Roberto brought us partly to Brazil through several scholars and cases around rational choice theory. Roberto, you didn't have to apologize for being an institutionalist. I'm also an institutionalist, and I believe that achieving commons can only be possible by the help of a legal framework that will enable the order and provision of services to people. You brought Thatcher to the scene with the statement about people must take care of themselves. And of course, it made me think immediately the third wave policies and neoliberalism, where individualism, consumerism, and self-interest are phrased through this kind of ideology and thinking. And perhaps, Roberto, here we can argue that law becomes a tool for self-responsibilization of the society. Of course, here we also have a paradox for ourselves, as institutions shoot us on the feet, I'm afraid. And moving to Joanna's presentation of Warsaw. Thank you, Joanna, for bringing me back to Warsaw. I actually experienced the transformation myself through my work in Warsaw in mid-90s. So most of the scenes, I missed that 1990 scene, but when I was walking around Palace of Culture, there were still some pieces of left in 1996. So I know exactly what kind of chaos you talk about, because when I was in Warsaw in those years, central planning, any word that contained central was out, and planning was very much connected to the idea of being central. So democracy was seen as something completely decentral. All these different municipalities declared their freedom, as you showed, which had spatial consequences. And of course, here we see the contrast between centralization and decentralization, because soon enough, this, what you call chaos, or what I call fragmentation, shoot back the society, because the developments became completely uncontrollable in many cases. And here you talked about the scale mismatch, and I think that's what unites the cases in Turkey, Brazil, and of course in Poland as well, the increasing tendencies of central control on the one hand, and of dissatisfaction of society and decentralization tendencies, either through these self-responsibilization or simply through dissidents, people who organize themselves through social movements. Joanna, you also brought spatial scale and property into the discussion, and that is, of course, very much connected. The loss of trust to central authority and central planning, of course, very much connected to the lose of control of the land and property development, as you very well showed. And perhaps I will stop here by saying that to instigate some discussion, maybe law becomes a tool for opportunism and opportunity-led spatial governance at the same time. So we see a very interesting face of law through these presentations. It's a rather ugly face of law. I wish Tobias was here to deconceptualize me a little bit, but maybe we can start the discussion from this point of view. Thank you. And of course, I'm just opening the floor for some ideas from you guys.
Can I present a slightly better, more positive view on the law? I apologize because I didn't bring a proper Brazilian example, but I thought it was important to discuss these overarching ideas. But at least in Brazil, after the fall of the military regime, when we had a new constitution and lots of social movements influencing this new constitution and our laws actually became our protection against too much greed. And social movements, urban social movements in Brazil use the law very much to defend themselves and advance their rights. So, but we had the very specific, special opportunity in which we had, the happiness to have such a progressive legal framework. But I don't think that is the same everywhere, of course.
Yeah, I just want to follow up on what you said, Roberto, also, because, you know, as Tuna mentioned, of course, law can be a tool of depoliticization of local government or voice of pushing through neoliberal agendas. But precisely in this flexibility of law that can be misused also lay the political potential of the law. And on the one hand, like currently in my current research, I focus on this flexibility and precisely how it's being used by urban movements. So one of my research is in Berlin with the initiative Deutsche Wohnen und Co. enteignen, which is a social movement that tries to leverage an article of a German constitution to expropriate corporate landlords, so big corporations that use housing to speculate on financial markets. At the same time, I also have a research project with a colleague from Warsaw where we look how people who took mortgage credit is denominated in Swiss franc, which was a moment in the whole Eastern Europe at least, now they tried to seek some sort of help after the franc was destabilized and they basically couldn't pay back their mortgage. They also found they're organizing themselves now through the law because the politics did not respond, the politicians did not respond to their claims. And last but not least, I was in Warsaw just till Tuesday for a couple of days, and currently there's a big influx of refugees from Ukraine. And I spoke to some of my friends who also work for the municipality of Warsaw, seeing how they also using this flexibility of law now to more effectively help refugees, to make available, for example, housing stocks that has been unavailable for a number of legitimate reasons. But of course, in the face of crisis, you have to touch upon this flexibility of law to make sure that certain things can be mobilized, certain resources can be mobilized very quickly, which shows again that what happens in the law is very much also a function of the political will. And that's this line that we have to always navigate.
Of course, I think Roberto wants to say something, but I thought that maybe I should come in between and say that I agree with that. But of course, we still have this problem of accountability, because in this flexible environment, flexible law environment, the mechanisms of accountability increases. We did some research a couple of years ago. We have more tools of holding someone accountable for this new environment on the one hand. On the other hand, it's very difficult to point out who is responsible for the delivery of good service. So this is something that we still have to figure out how to deal with. I'm sorry to intervene. I think Roberto and then Şence has some comments.
I just wanted to add that the flexibility of the law is exploited by those who know the law and who can hire lawyers or understand how they can circumvent the law. But I think there is another dimension that, as good institutionalists that we are, we have to look at them, are the informal institutions. So the ways of doing things and cultural attitudes and norms that influence how the law is enacted and interpreted and lived in real life. One thing is the letter of the law, and the other is how it is lived in reality, right?
Yeah, it's very true, and I also agree that what you say about who knows the law, and my question always is, do we actually educate planning students really knowing the law? It's a big question mark in there. And if you see them around the table with the private industry, the property industry, where they know their contracts very well, I think we see the gray zones there. Perhaps a little note for ourselves, for planning educators to pay some attention to. I think Şence wants to say something.
I agree with you related to your opinion related to law's effects. You are right. In my opinion, this flexibility type of the regulation in favor of the private sector. But it's interesting thing, this regulation was made within the public law. Public law and private law, their relation is quite different here. Under public law gives priority private law, but there is a problematic issue, accountability, discretion. The public law don't solve this problem, I think. This is very huge problem. Now, normally we expect public law solve this certainty, they give certainty and decrease the creation and accountability, no accountability problems within the urban public law. But when we look at the urban law situation, we use private law tools, but there is no any accountability problems. There is no solving any solution related accountability problem. There is a high level discretion and there is no certainty. This interesting thing here, I think. You are right. I'm accepted this a type of the regulation in favors of public-private sector, private sector.
Yes, and maybe a little bit contradicting to the expectation, property industry loves certainty. And I mean, you were referring to private law, and if you, I mean, in our current research, we are having these conversations with the different property industry actors. And I think the common discussion coming from these interviews, or common idea coming from these interviews, is that they prefer rather certain, well-defined boundaries. Even if it's demanding too much from them, they prefer to know the time limits, the budget limits, the physical boundaries, locational choices, which I find it very interesting, because if you look at planning tendencies, even in a city like Amsterdam, which is the heaven of planning, you would say, where we are only creating visions. We can't actually create certain zoning plans or master plans with 100% certainty. This environment, I think, there are some new positions of the public and private actors are also emerging.
Mm-hmm.
Okay, so maybe we have some questions also from the public.
Yes, I can read them for you. There is one for Joanna from Monica Lopez Franco. She says, Thank you, Joanna, for your presentation. It was so interesting and got me thinking of something I've been realizing lately in Mexico, which is that most developments are categorized as condominiums, which means the building and what happens within it is regulated by the developer and tenants, and there is no alternatives from the law. What are your suggestions in the case of Warsaw and in general to other places?
Thank you for the question. I'm not sure I entirely understand how can I be the most helpful here, but I think I would just reiterate what rings all the time for our discussion, namely that this issue of legal literacy, and that by and large, we as planners, we as activists, we need to be more attentive to these little technicalities and definitions of law. And that's of course not easy, because law, not accidentally, but actually law is very intentional in concealing itself as a political domain through the legal language that is often hard to understand, and that is making things sound more complicated than in reality they are. I mean, it's a very expertise-driven domain, and as such, highly exclusive. However, as I have argued also in other paper where I introduced the idea of so-called critical legal engineering, where I argued that non-lawyers can also access this sphere of law and legal flexibility to propose also their own interventions. And of course, that is not easy. And as I said, the law doesn't make itself accessible. But I would say that law is too important sphere to be left to lawyers only.
I'm sorry. Thank you so much. And there is a question from Ebru Kurt. Many thanks for all interesting talks. My question will be for Professor Türk. How does she interpret the urban transformation processes in Turkey under increasingly authoritarian and accordingly interventionist attitude of the state?
Okay, thank you very much. Your question. I can say the law quite important thing. As you see, some within the urban law, there is a huge intervention. For example, intervention to ownership. For example, this is a authoritarian behavior, I think. Ownership quite important according to our constitution. When we look at nowadays, until now, the property protected by the state, but today with the Urban Renewal Act, different things here, intervention to private ownership by the law. This is very problematic issues. This is authoritarian behavior, I think. Thank you very much.
Thank you very much for your answer. We have other questions, but I'm afraid we are exceeding a little bit of time. But I believe during our discussion time, we touch on some of these questions, which is great. And before we conclude this session, I just would like to ask to our participants if they can tell us what they did take from this session. Is there anything interesting they saw from other presentations, or any new ideas coming up? So perhaps we can start with Roberto.
So going back to what Joanna said about legal literacy and the flexibility of the law that was explained by Professor Türk, I think trying to answer what Tuna asked before, are we teaching the right stuff to our planning students? And my impression is that we are not. And we need to find new ways to teach what are institutions, what are legal frameworks, and how can we deal with them in real life.
Thank you so much. And Professor Şence Türk.
Thank you very much. This is very interesting meeting. Thank you, Tuna. What is that?
Okay. Joanna, if you have any final.
I think two things I took from it. One is a lot of joy. I think that counts as well, just a pleasure of discussion. But I think also this intersectoral potential that we really have, and I think that could be felt in our discussion that, like, in some sense, hopefully it's a sign we're moving away from this very rigid disciplinary boundaries where the planners do the planning, the lawyers do the law, and the sociology does social movements, where we really learn, I think all of us learn to navigate these different disciplines and bring them together to create this added value. And I think this was a very interesting example of it. So thank you so much once again for the invitation.
Thank you so much. And Professor Tuna, please.
I think, I definitely join Joanna for the joy. And I think what is more interesting for me, once again, to look back to this idea of flexibility. I did work on the idea of guided flexibility some years ago. It's over 10 years ago now. I think I thought when listening to you, it's time to go back maybe to that idea and look from law's perspective, because also in the Netherlands, we are facing this new law, the Omgevingswet, which is the new spatial law act. And that contains lots of flexibility, but also lots of new tendencies of controlling urban development. So I think we need some new studies in that field, flexibility in law.
Thank you so much. And this is the end of our session. This was the last episode of Law and Policy webinar series. For the moment, please stay tuned for our next events. If you can visit the website of UGoveRN.eu, you can see our next events and next activities of Law and Policy chapter, along with other research teams. I would like to thank to our panelists for their amazing input and for attendees as well. I just would like to remind our participants to check their inboxes right after this session. So we just like to offer our thanks in a small informal meeting. But thank you very much, and good evening from Istanbul.